Hello, my name is Robert Reeves. I'm a South Carolina workers' compensation attorney. This video is designed to give you an idea of what to expect at a hearing before a workers' compensation hearing commissioner. It is not designed to train you to represent yourself. Quite frankly, if you are about to go to a hearing, you absolutely need experienced workers' compensation counsel. Now, just a little bit about my background, so hopefully what I tell you in this video has some credibility. I've practiced South Carolina workers' compensation law for 31 years. I started out as an insurance defense lawyer, and I've handled probably several hundred cases over the course of my career. Now, the first type of hearing is going to be a denied case where your claim has been denied by the insurance company, and you and your lawyer are going there to fight to win benefits. Now, you both arrive at wherever the hearing is going to be held, and before COVID, you would wait in the hallway or in a waiting area. Now, with COVID, I believe you wait outside until they telephone you to come inside the building. First thing is the lawyers, your lawyer and the insurance defense lawyer, go into the hearing commissioner's room alone, and that's where the hearing commissioner listens to both sides, goes over what the issues are, where we agree, where we disagree, in order to simplify the hearing once they go on the record. Once that process is completed, then they come outside and get the parties. The insurance defense lawyer will get the insurance adjuster if they're there, possibly a representative of the employer, and of course your lawyer will come get you. Now you go in and you'll see it's fairly informal. It's usually at a table with the commissioner in the center, a court reporter, and then you and your lawyer sit in one end and the insurance company lawyer and their representative sit at the other. The case is called and they go on the record. What does that mean? That means that everything that is being said there is being recorded and can be reduced to a transcript in case there is an appeal later. Now, because it is always the claimant's burden of proof, then you go first. So your lawyer will go on the record and state our position as to what you agree on, what you disagree on, and what the issues are at the hearing today. Then the defense lawyer will respond with also where they agree and disagree and where they think the issues of the case are. And then witnesses are called. Again, it's your burden of proof, so your lawyer will call you to start testifying. You'll sit where you are. You'll have to raise your hand and swear an oath to tell the truth, the whole truth, and nothing but the truth. And then your lawyer will ask you a series of questions. In a denied case, the facts are very, very important, and so they're much more detailed as opposed to a case where liability has already been admitted. So they usually start off with your name, age, education, work history, and then what happened on the date of accident. And at that point, you need to be as detailed as possible, because the more details you give, then the more of a record is created and more evidence the commissioner has to make a decision. After your lawyer finishes questioning you, then the insurance defense lawyer will have a chance to cross-examine you. And that's where they'll ask you questions that they believe show that your case should be denied or that there's some sort of credibility issue with your presentation. Now, at the end of that cross-examination, then you may have some additional witnesses who can testify about what happened. Maybe they saw you get hurt. Maybe they heard you were hurt. Maybe you reported it to them more quickly than you did to the employer or seeking medical treatment. And then those witnesses are also subject to cross-examination by the insurance defense lawyer. At the conclusion of your case, then the insurance defense counsel has a chance to put on witnesses if they need to. Sometimes they believe that the case that you've presented is so shaky that they do not need to put up witnesses. Other times they may put up just as many or more witnesses than you did. At the conclusion of the evidence, then the hearing commissioner will usually ask if there's anything further. Both lawyers will say, "No, Your Honor," and then the record is closed. Now, in most cases, the hearing commissioner needs to go back and review the medical records and review their notes before rendering a decision. In rare cases, they may actually rule from the bench, but in most cases, they will send your lawyer, and both lawyers, frankly, an email later indicating how they have found and how they have ruled, and ask one of the lawyers to draft a proposed order. So that's what to expect in a denied case. Stay tuned, more videos are coming.